that the proceedings are audio taped, and he can request a copy of the audio tape from the clerk.
You ready, Mr. Judge?
Yeah, if we're going to go forward with the arraignment, I've just got some questions that I want to ask.
Before you ask your questions, why don't you let the court do the arraignment, and it might answer some of your questions.
Okay, yeah.
The purpose of this hearing is to evaluate your constitutional rights to charges against you and possible penalties which may be imposed. You have the right to remain silent. Anything you say can and will be used against you in court. You have the right to have counsel present for all proceedings. If you're unable to afford counsel, file an application to the court. If the court approves, counsel may be appointed to represent you. However, the court may require you to repay the cost of court appointing counsel if your financial circumstances change. You have a right to waive or counsel represent yourself if you so desire. You have a right to a hearing in this matter and to confront witnesses who may testify against you. You have a right to subpoena witnesses on your own behalf at no cost to you. It is the city's obligation to prove beyond a reasonable doubt that you are guilty of the charges. You have the right to plead guilty, which admits the charge, not guilty, which denies the charge, guilty but mentally ill or no contest, which is a guilty plea. However, it may not be used against you should there be a civil matter pending. If you do not understand both rights, please ask the judge for clarification. Do you understand what we went over?
Somewhat.
Any questions?
Well, I want to appear specially for the purpose of challenging the jurisdiction.
Well, do you understand what we went over here on this?
Not really. I realize, I guess, I don't understand the nature of the charges against me. I presumed innocent until proven guilty?
That's up to you.
Well, no, Your Honor, the question he asked is he presumed innocent by the court until I prove the case? That's the question he asked you.
Okay. And yeah, I guess he would be, huh?
That's correct, Your Honor. He is innocent until I prove him guilty if he enters a not guilty plea.
Right. So are we ready to proceed here?
Well, so this is a designated court of record, and I'll be allowed to get a transcript of the proceedings?
You bet.
You would have to pay for the transcripts with a $100 deposit. You can get a copy of the audio, but if you want a written transcript, you have to pay for that.
So is the nature of the proceedings against me criminal or civil?
These are criminal proceedings. You're charged with violation of Nevada Revised Statutes 485-187 and no valid proof of insurance.
But I still have to pay for a transcript in my own defense, even though it's a criminal proceeding?
That's correct. That is what the law says.
And it's $100, huh?
Deposit. Once the transcripts are done, depending on how much just depending on how much the total bill is, you'll have to pay the difference, or we will refund you the difference. But it's a $100 deposit.
Huh, okay. So I'm entitled to a fair and meaningful hearing?
Everyone is.
Who do you represent in the hearing?
The county, the city.
You represent the city?
Yes, I'm the city judge.
And then Odgers, Mr. Odgers represents the city also?
For clarification, Your Honor, you don't represent the city. I represent the city. You represent the people.
Thank you.
The people of the city?
People of the state. You violated state law. It's in the jurisdiction of the city. The judge is sitting as an impartial arbiter of the case. The law requires me, as you were told during the arraignment, to prove each and every element of the charge against you with the no valid proof of insurance, NRS 485-187, which you and I both went over when you came to my office. So you know what I have to prove.
So you represent, is the city your employer? Does the city pay Mr. Clares?
Oh, yes.
The city is your employer. So it's true that I'm entitled to be informed the nature of the causes, or the nature and cause of the charges lodged against me?
You haven't gotten to that point yet, but yes, he is.
Yes.
Well, I thought that was what you was explaining for the...
No, he asked you if you understood your rights on the arraignment, and then you started saying you had some questions.
Okay.
We haven't gotten to that portion of the arraignment yet, because you're still asking the questions about your rights.
So I'm entitled to a responsive answer to the relative questions I have about the charges and proceedings.
I'm not even sure I understand the question.
Yeah.
If you understand the arraignment, will you sign and date that for me, please?
Well, I don't understand it. That's why I'm doing these questions.
Then the questions need to be about what.
Your rights, what the arraignment is regarding.
Yeah, okay. Where is the rules in the rules and laws that govern these proceedings, and where would I be able to find them?
That is your responsibility. If you're choosing to represent yourself, you're
Okay,
presumed to be responsible for your own defense. But proceedings are found in Nevada revised statutes.
So is it the court's opinion that the complaint created and lodged with the court is a valid prima facie complaint?
Yeah, it's inappropriate at this point for the defendant to be grilling this court regarding what I think he's trying to get to is your ability to remain neutral. If he has a question or if he has a challenge to the citation that's issued, after he enters his plea, and if he pleads not guilty, and we set this matter for trial, he can then challenge the sufficiency of the complaint through motion, which is the appropriate way to do it. The court has no obligation to answer questions regarding the court's position on anything other than the fact that your job is to remain neutral as a neutral fact finder, period, in the story. I'm not sure what Mr. Judd's intent is, but he's delaying these proceedings by asking questions that are unrelated to the rights that you've explained to him already.
I would like to know why is that unrelated, and I am not trying to delay. I'm just asking a simple question. If the complaint is a valid prima facie case, I pointed out a couple of things that I felt was wrong with it, and I never got much of an answer other than you're accusing me of stalling. I find it, I don't understand that.
Your Honor, it's really simple, and Mr. Judd is a very intelligent man, and what I guess he's failing to understand is the purpose of this hearing is to advise him of his constitutional rights, to accept a plea, whatever plea he wishes to make on his own free will, and then to move forward. It's not for him to cross-examine the court. It's not for him to cross-examine the city. It's a question of whether or not he understands his constitutional rights related to this citation. If he has issues, those issues are more appropriately dealt with through motion practice if he enters a plea of not guilty.
Do you understand that?
I thought that was, I have a right to understand my constitutional right. I thought that was isn't that before you enter a plea, don't you have to be fully informed?
Correct. You have to make a knowing voluntary waiver of a guilty plea. Your plea of not guilty is based upon you have the right to have an attorney If you can't afford one, and if the city's seeking jail time, you may be appointed one. If the city's not seeking jail time, you're not entitled, guaranteed to one. You're entitled to a trial. At that trial, the city will be required to prove beyond a reasonable doubt each and every component of the charges being brought against you. You have the right to subpoena witnesses. If you give that information to the city clerk, to the court clerk, and the court clerk will get them subpoenaed and brought here for you. You'll have the right to appeal if and when that point comes. Those are the constitutional rights that we're talking about in your arraignment.
Do I have the constitutional right to understand every element of the charges against me, including jurisdiction?
Jurisdiction is a question that you would have to bring up in a motion. This is not the appropriate time or place to be arguing.
Well, I'm not arguing. I just got several questions. It's all questions.
Questions are still considered an argument in this particular case. Those are questions, if you have, that you need to either do through motion practice or by retaining a counsel.
So, no more questions?
If they're about your constitutional rights, I won't have any problems with it.
Well, you got a constitutional right for a fair and meaningful hearing, correct?
Trial.
Hearing. And this is an arraignment, so it's not considered a hearing.
This is an arraignment. This is simply to convey to you your constitutional rights and make sure that you understand those rights that have been enumerated to you, both verbally and in writing in front of you. If you have questions about those, I have no problem if you ask those questions.
So I am required by law to enter a plea of at this time.
You're required to either enter a plea of not guilty, no contest, or guilty. Or if you choose not to enter a plea, then I'll ask the court to enter a plea of not guilty and set this matter for trial.
Yeah, I don't understand the alleged crime against me, so I guess I'll just enter a plea of not guilty.
Okay, then we'll set a date for trial.
What's that?
We'll set a date for a trial.
Yeah.
January 11th at 9 a.m.
Will you be getting an attorney, or will you be?
I can't afford one, but I don't know what the burden is to meet it. January 11th at what time?
9 a.m.
Oh, I had one more question. Am I entitled to any jury trial? Can I demand a jury trial?
No, this is
Not in the state of Nevada. Misdemeanors are not. You can't get a jury trial on a misdemeanor under Nevada law.
Under Nevada law, you're not. You can't get a jury trial.
No, you cannot.
Even if I demand it, there's no demand.
No, there's no demand. You can submit your demand and I'll oppose it and I'll give you the citation, but I will ask for sanctions for releasing court's time for filing frivolous lawsuits. Part of representing oneself is that they're held to the same standards as I am as an attorney.
Well, isn't there a rule that if a guy's pro per, the court will extend your latitude as a pro per, and you're not bound by the rules?
No.
There is no rule for
You're
that?
expected to behave and to be as knowledgeable as the attorney.
Expected to behave and as knowledgeable as the attorney, yeah. So there's no such rule. Is any latitude extended?
No.
No?
Such rule.
No, I mean, the court will give some leeway But if he starts filing frivolous motions that aren't supported by the law, and I will seek sanctions, just as I would against any other lawyer.
So I'm threatened with sanctions to file a motion for a jury trial.
Yeah, that one I will ask for sanctions. There's proper research in Nevada revised statutes and case law to tell even a layman that you can't file a motion for a jury trial in a misdemeanor, because the Supreme Court and the state of Nevada have said that misdemeanor trials are not subject to a jury trial, not entitled to one under the Constitution of the state of Nevada.
Then that's the state constitution. Don't the federal constitution trump the state constitution?
Not on this issue.
Not on this issue. So are these proceedings criminal or civil?
We've already answered this. This is a criminal.
Criminal. Okay, that's what I thought.
Nothing else, Mr. Rogers?
I don't have anything. If Mr. Jed has more.
I just had a few more questions, but I don't know if I got them all in or not. So I guess my other question is, if I file a motion for you to approve the jurisdiction of this case, you're going to file sanctions against me for that too? And explain the sanctions. Is that something that if you file sanctions against me, I got to get my motions approved by another court before they are filed? Is that how that works?
No.
I'm just barred from justice from the court if I'm sanctioned?
Sanctions mean if you waste the court's time, you waste my time, I can ask for financial sanctions. I can ask the court to do any number of things.
In a criminal proceeding?
In a criminal proceedings, including having you declared to be a vexus litigant. If you waste time and dollars on motions that are baseless as a matter of law. Jurisdiction is an issue. If you want to challenge the jurisdiction, file your challenge of jurisdiction. We'll have a court hearing on it. But it has to be an appropriate motion. The idea that you can say, I challenge the jurisdiction of this court, or I challenge the jurisdiction
My
of the
motion
city.
so far hasn't been appropriate?
The one definitely was not, because it dealt with news reporters. 229 specifically says news reporters. In the
Well,
state.
I certainly object to that, Your Honor. If you'd read that motion, I'd appreciate it and enter a plea, or enter a written response to it.
Well,
I appreciate
The
you
court's
allowing
already-
me to go ahead with this, but under that rule, there's, from what I understood, they're supposed to enter a written response.
Your Honor, I'll just give you the definition real quick, since we're going to go back to the motion that the court's already ruled on.
Can I have a copy of that?
No, you can pull it yourself. I don't have
Okay.
an obligation to provide you with a
All
copy of
right.
the law.
All right.
Supreme Court Rule 229, definition and scope, defines a news reporter shall include any person who gathers, prepares, collects, photographs, records, writes, edits, reports, or publishes news or information that concerns local, national, or international events or other matters of public interest for dissemination to the public. And then under scope, it says, these rules do not govern the coverage of a proceeding by a news reporter who is not using a camera or electronic equipment. Except as provided by these rules, the use of cameras, cell phones, or other electronic devices to photograph or record courtroom proceedings without the express permission of the judge is prohibited. You gave him permission. So the motion is void at his face because A, he's not a news reporter, or at least he doesn't indicate he's a news reporter in his motion, and B, you've already given the verbal authorization to videotape. So I'm not sure where he's going to with that. So the motion under 229 that he filed should, I believe the court denied it because he doesn't meet the very minimum requirements of being a news reporter. And then the court granted him leave to videotape. So I'm not sure where he wants to go with that. So
I'm just asking what the minimum requirements for a news reporter is. That don't make much sense to me.
well, it gives you the definition. You don't report, gather, prepare, collect, photograph, record, write, edit, report, or publishes news or information that concerns local, national, international events or other matters of public interest for dissemination to the public. Your motion even said that you wouldn't be disseminating it. It would be for your own personal use. Hence, you're not a reporter.
Okay.
Okay, so what do we do here?
It's up to Mr. Judd. If he's got more questions he wants to ask the court, I'll make any objections I need to make.
Is this court bound by any of the Ely court or Ely city ordinances?
Well, yes, what do we?
All of them?
I'm sure whatever ordinances we have to have, yes. Anything else, Mr. Judd?
No, I'm presumed innocent of the alleged crime. Mr. Rogers answered the question that he's got. I can file a motion for the jurisdiction. So. Nope. What was the time and date again? Oh,
He still needs to sign the.
this is the arraignment thing that I gotta sign it.
Need to sign and date it, please. January 11th at 9 a.m. is the trial date.
I think I wrote that down.
If nothing else, we'll go ahead and recess.
Thank you, Your Honor.
I'm sorry, I didn't stand up.
Remember, any evidence you are going to try to introduce at the time of trial, you need to make sure I have at least 5 days before trial.
What, I don't understand this, dated this day of.
Today's
20.
the 7th day of December 2016. Today is the 7th day,
Of December, but what's the 20?
2016.
Oh, 2016, oh, okay, so it needs another thing over here that says 116, and this needs to say December, I see.
Yes.
And you know my mailing address.
You had a P.O. box, you said, right?
Yeah, yeah.
What is it?
P.O. Box 121, Lund, Nevada, 89317.
Okay.
Thank you.
So the two gentlemen that are,
Yeah,
are they headed back?
yeah, they were just
Indiana.
traveling through town.
Okay, we'll get on to Mr. Lewis next.
Yeah, we'll get into taken care of real quick.